Hello friends, Jai Hind. Today we'll be discussing a very interesting topic, that is Collegium versus the National Judicial Appointment Commission, NJAC. We'll discuss the appointment of judges to higher judiciary in India. It's an important topic from the UPSC point of view and other competitive exams point of view. Now let's see, in other developed countries of the world, in the United Kingdom, the Queen or the King appoints judges to the Supreme Court of United Kingdom on the advice of a 15-member body known as JAC, Joint Appointment Committee. Now it's a very comprehensive process, and even the interviews of judges are taken before appointing them as Supreme Court judges. And mind you, out of these 15 members of the JAC, only 3 are from the judicial fraternity. Rest all are eminent personalities of different fields. And there are only 3 judges amongst these 15 people. Now come to USA. The Supreme Court judges there are appointed by the President. The President sends names to the Senate. Senate deliberates on it and recommends the names back. The Senate passes the names by 2/3 majority. I repeat, they are appointed by the President. The names go to the Senate for deliberation, and the Senate passes it by 2/3 majority, and thereafter the President appoints those judges. So in both UK and USA, so-called developed countries, the judges are not appointed by judges, they are appointed by the executive. Now let's go down further. What happens in India? The Indian judicial appointment system, which is existing as on date, is being criticized on the point that in our country, in India, the judges appoint the judges. How does that happen? Let's see. Firstly, let's see what does the Constitution say. The Constitution says, Article 124(1), it reads that India shall have a Chief Justice and 7 judges. And this strength or number of 7 judges is amendable by the Parliament. The Parliament can increase or decrease it. And the judges of Supreme Court shall remain in office till the age of 65 years. Now, over a period of time, the number of judges have increased. And the most important amendment came in the year 2019. The case was Number of Judges Amendment Case, Act 2019. The strength as on date is 1 Chief Justice plus 33 judges. That makes it a total of 34 Supreme Court judges as on date. The Article 124(2), it says that the Chief Justice of India will be appointed by the President of India in consultation with the judges of Supreme Court and High Court. This is what the constitutional provisions say. What does the constitutional provision say about the appointment of other judges? Let's see. It states, other judges would be appointed by the President, but compulsory consultation with the Chief Justice of India is a must, and with other judges if required. So when appointing other judges of the Supreme Court, the Chief Justice has to be consulted by the President, and other judges can also be consulted in case the President feels so. Now this is what the constitutional provisions are. The Constitution clearly says that the executive will be appointing the judges and not the judges appointing the judges. Now how did this situation occur in India, wherein gradually the judges started appointing themselves? This resulted because of the Collegium system. A system came into India which is known as the Collegium system. It evolved over a period of time. And how did it emerge? Let's read it further. We go down further. Emergence of the Collegium system in India. You see, in India, the Constitution doesn't talk, nowhere in the Constitution it is mentioned that there will be anything like a Collegium system for appointment of judges. It's an invention of the Indian judiciary, and we'll go into the history of the collegium system. During Pandit Nehru's time, a very amicable relationship existed between the judiciary and the executive. Appointments were done by the executive. Executive means the Council of Ministers, the President on the advice of the Council of Ministers and the Prime Minister. And during Nehru's time, the rule of seniority, the senior-most person or the senior-most judge was appointed as the Chief Justice of India. That rule was being followed. And so long as that rule was being followed, there was no crisis. Wait a minute. So as far as that rule was being followed, there was no crisis of any kind. And now when we go down further, okay, we were discussing that during Nehru's time the rule of seniority was being followed, and so long as the rule of seniority was being followed, there were no dissensions or there were no disagreements or there were no cribs of any kind. However, during Nehru's time also minor crises did occur. What were those minor crises? In 1950, Jawaharlal Nehru wanted to appoint M.C. Chagla as the Chief Justice of India. However, most of the judges were furious. They offered to resign. And Nehru learnt his lesson and he pulled back the offer. Thereafter, peace prevailed till 1964. In 1964, there was a very genuine case. The case was that the senior-most judge was Justice Zafar Imam, Justice Syed Zafar Imam. He was to be promoted to the post of CJI, but he was not promoted as CJI due to health issues. There were certain psychiatric issues, there were certain health issues. For a couple of months, Justice Zafar Imam couldn't join the office. And on the advice of the then Attorney General, Pandit Nehru requested Justice Imam to resign, and the next in seniority, Justice P.B. Gajendra Gadkar was appointed as the Chief Justice of India. And there were no cribs from any side because the reasons were very genuine. Other than that, there were no issues regarding judiciary during Pandit Nehru's time because the rule of seniority was followed in letter and spirit. Then came the tenure of Lal Bahadur Shastri ji. And during Shastri ji's tenure, a short tenure though, nothing went wrong, the rule of seniority was followed. The problem started occurring during Srimati Indira Gandhi's tenure. As we are all aware, Mrs. Gandhi had a different view of handling the other, had a different view of governance. Rift started between the executive and the judiciary during Prime Minister Indira Gandhi's time. 25th April 1973, Justice Ajit Nath Ray, he was made the Chief Justice of India, superseding 3 senior judges. Those who were superseded were Justice J.M. Shellet, Justice A.N. Grover and Justice K.S. Hegde. All these 3 senior judges who were superseded resigned. Now let's see how did this particular thing happen. Why this particular favor was done to Justice A.M. Ray? There were reasons to it. And we have to go into the reasons. What were the reasons of favoring Justice A.N. Ray? See, on 24th April 1973, just a day prior to the elevation of Justice A.N. Ray, the Keswanand Bharati case decision had come through in the Supreme Court. And we are all aware the Keswanand Bharati case which had promulgated the basic structure doctrine into the Indian system. It was a 7:6, a very close judgment. 7 judges said yes, the basic structure exists. 6 judges said no, nothing like basic structure exists. It was a split decision, and the decision was in favor of basic structure doctrine with 7 judges in its favor. just an increase of one judge. Now see, Justice J.M. Sellert, Justice A.N. Grover and Justice K.S. Hegde were a part of the group that gave validity to the basic structure doctrine. They said, yes, the government cannot change the basic structure, or the parliament cannot change the basic structure of the constitution, and something like basic structure doctrine exists. And there were 6 judges who said nothing like basic structure exists, and Justice A.N. Ray was a part of those 6 judges who said nothing like basic structure exists. Mrs. Gandhi was happy with Justice A.N. Ray. And since A ruled in favor of Indira Gandhi or the executive's opinion, the favor was returned back or reciprocated in the form of elevating him to the CJI. This is what is generally alleged. Now let's go down further. Herein the judiciary got antagonized even further because 3 senior judges were superseded, and suddenly Justice Ajit Nath Ray was elevated to the CJI. The 3 senior judges resigned, and there was bad taste all over. Another issue. You see, 1975 internal emergency was declared in India by Mrs. Indira Gandhi, and it's been criticized widely since then. And in 1975 only, an important case came in front of the Honorable Supreme Court, and that case was ADM Jabalpur versus Shivkant Shukla case. And this is also very importantly known in the Indian history of judicial decrees as the habeas corpus case. Now what is habeas corpus? We all are aware that habeas corpus is a writ. It's a writ against unlawful detention. Article 32 it can be applied under Article 32 in the Supreme Court and under Article 226 in the Honorable High Courts. We just discussed 75 emergency was declared, internal emergency was declared, and a question was brought in front of the Honorable Supreme Court that can habeas corpus be implemented during emergencies too? A 5-judge bench was to decide this issue. And see, out of those 5 judges, 4 judges ruled in favor of the executive. They said habeas corpus does not apply during emergency. 4 judges said habeas corpus has got no relevance during emergency, and during emergency arrests can be made at the discretion of the executive. Only one judge, Justice H.R. Khanna, ruled against this particular opinion of the 4 other judges. Justice Khanna said, yes, even during emergency, habeas corpus is applicable, and it was a very bold decision. It is believed that Indira Gandhi was not happy with this particular kind of decision of Justice Khanna. And so see what happens. The very next year, that is in 1977, the Chief Justice was to be appointed. Justice Khanna was the senior-most amongst all the judges of the Supreme Court. But somehow Justice Khanna was superseded, despite being the senior-most. And Justice M.H. Beg was made the CJI of India by the Indira Gandhi government. And obviously to the public this appeared an act of reciprocal favoritism, widely criticized. So thus 2 supersessions occurred during Mrs. Gandhi's time, and the judiciary got antagonized. The 2 supersessions were, first was in 1973, where 3 judges were superseded, and 4th A.N. Ray in seniority was elevated to the position of CJI. Whereas in 1977, Justice Beg was made the CJI by superseding Justice Khanna. Thus, the rule of seniority was broken by Indira Gandhi twice over, and this antagonized the Indian judiciary and the public at large too. Now let's see. Let's go down further. Now the judiciary was antagonized, and first time in the year 1981. Now, gentlemen, just for your information, we'll be discussing 4 important judges' cases that are known as the first, second, third judges' case and the fourth judges' case also. In 1981, the first judges' case occurred. This is also known as the S.P. Gupta versus the Union of India. Article 124 was discussed, and the question before the Honorable Court brought was, does consultation mentioned in the Indian Constitution mean concurrence? Means, is consultation with the judges binding on the President? And in a very important judgment, in the first judge's case, the Supreme Court ruled, no, consultation doesn't mean concurrence. The Supreme Court clearly said, consultation mentioned in the Constitution is not concurrence, and thus the decision went in favor of the executive. The judges were to be appointed by the executive at their discretion. So the first judge's case went in favor of the executive. Now comes the second important judge's case, or the second judge's case. See, in the second judge's case, the Indian judicial history to some extent starts changing. How? 1993, the second judge's case came in front of the Honorable Supreme Court. This was also known as the Supreme Court Advocates on Record Association versus the Union of India. And what was the question before the Honorable Supreme Court? Does consultation mean concurrence? Once again the same issue came. And this time, very interestingly this time, the Honorable Supreme Court during the second judge's case took a U-turn. U-turn on its own previous decision. The Supreme Court ruled, yes, hereafter consultation means concurrence. The President will have to abide by the advice of the CJI and the other judges. The President would appoint judges of Supreme Court and High Court by consulting the Chief Justice of India and 2 senior-most judges. Note herein it was CJI plus 2 senior-most judges, and later on, after the third judge's case, it will become CJI plus 4 senior-most judges. So this difference you have to understand. And thus, from the second judge's case onwards, the collegium system started, although in a miniature form, although in a smaller form. Further, the Honorable Court said the decision would be based on primacy principle. And what is this primacy principle? It means that views of the Chief Justice of India would be of prime consideration. The CJI's views would be deemed to be the view of the judiciary. Interesting. That means whatever the CJI says would be final. So de facto, all powers got concentrated in the hands of the Chief Justice of India after the second judge's case. So, and consulting the 2 other judges, the 2 other senior judges which we discussed here, was a mere formality. Further, the Honorable Supreme Court says that the rule of seniority would be followed. So after the second judge's case, formally a small little collegium system started. Small little I am mentioning because it was CJI plus 2 judges. We go down further and see what happens in the third judge's case. The third judge's case is a very interesting case. 1998, under Article 143, a presidential reference came to the Honorable Supreme Court. You see, under Article 143, the President can refer any matter for advice of the Supreme Court. This is also known as the reference case, Appointment of Judges case 1998. So Article 143, President can ask for opinion on any subject, and this time in 1998, Honorable President inquired, what did he inquire? Firstly, does consultation mean concurrence? Secondly, the Honorable President inquired, isn't it wrong to concentrate all powers in the hands of the CJI alone? The primacy principle. The Honorable President inquired, what does consultation mean? Does it mean concurrence? Secondly, I stand corrected. Secondly, he inquired, isn't it wrong that the primacy principle concentrates all powers in the hands of the CJI? Now what does the Honorable Supreme Court say? Let's go down. In the third judge's case, the Honorable Supreme Court ruled, yes. It again reiterated that consultation means concurrence. Yes, consultation means concurrence. You will have to concur with the decision or directions or the opinion of the CJI and the judges. However, the Honorable Supreme Court diluted the primacy principle a little. It expanded the collegium to 5 members. Earlier, how many members were there in the collegium? 1 CJI plus 2 members, 3 members only. This time it became 5 members. That is 1 CJI and 4 senior most judges. That means 2 additional judges were added to the collegium. Further, the Honorable Supreme Court said in the third judge's case, they introduced a system of due process. It says in case the collegium follows due process, the decision of the collegium becomes binding on the president. In case the due process is not followed, the presidential assent can be denied. Now what does the due process mean? Due process means the following. Sorry, let's go down a little further. Meaning of due process. It was a process led by the Honorable Supreme Court. It said no names to be forwarded without concurrence from the CJI. Again, importance of CJI was reasserted. Means, in a way, the CJI got the veto power. In case the name is forwarded without the concurrence of the CJI, the President is not bound to accept it. Name of recommended judges be forwarded with majority decision, including CJI. Again, the caveat was put, CJI has to be included in the majority decision. Mild democratization of the collegium was done, but the primacy of the CJI was still retained to some extent. Further, the Supreme Court said, majority decision means CJI plus 2 judges. Total 3 judges. CJI has to be a part of the majority decision. Without CJI, the majority decision will not be accepted. The Honorable Supreme Court further said, seniority will be considered. It will be given its due importance. But if there is a clash between seniority and merit, merit will hold supremacy or precedence. It further said, in case any judge recommended from some high court, in case the name of any judge is recommended for elevation to the Supreme Court from some high court, and already any judge from that high court exists in the Supreme Court, the opinion of the already existing Judge X that high court would be considered and forwarded in a separate envelope to the President. To clarify it further, let's presume that somebody from the Rajasthan High Court has to be chosen as a Supreme Court judge, and already a judge in the Supreme Court exists from the Rajasthan High Court. So opinion of that already existing Supreme Court judge, ex-Rajasthan High Court, will be taken for elevation of the latest proposed addition into the Supreme Court. Let's go down further. Further, the Honorable Supreme Court says, President is bound by the advice of the Collegium. Thus, in the third judge's case, the Collegium was fully established in 1998. Hereafter, the entire powers went to the Collegium. And the only difference was that in the second judge's case, the Collegium was the CJI plus 2 judges. Herein, the Collegium became CJI plus 4 judges and 4 senior most judges of the Supreme Court, and mild democratization of the Collegium system was done. Now, gentlemen, the collegium system has been criticized widely. What are the various kinds of criticism? Let's see. Criticism of the collegium system. They say it's an absurd interpretation of the Constitution. The Constitution nowhere talks about collegium. The Constitution has given powers to the executive for appointment of the judges. But however, over a period of time, the collegium system has evolved. And the Honorable Supreme Court has almost made it totally legitimate. So people to criticize it say that it's an absurd interpretation of the Indian Constitution. They say it's a strange and unique appointment procedure. There are no parallels in the world. Most of the democratically advanced countries, the executive appoints the judges, whereas in India the judges appoint the judges. What a strange system. Further, they say it leads to nepotism, and there are evidences to support that. On the 52% of the judges in the Indian judiciary are relatives of the judges. It can't be a mere coincidence. Well, I'm not questioning the competence of the judges, but it can't be a mere coincidence. See, we must have heard the names of Khannas, the Chandrachuds, the present CJI D.Y. Chandrachud, son of Y.V. Chandrachud, the Katjus, the Kaniyas, the Bhagwatis, the Misra, the Sikri, the Lalits, Justice Joseph, son of Justice Matthew, etc., etc. And the list is quite long. If that is an indicator, that's also in criticism. The collegium system is against the separation of powers principle enshrined in the Constitution, and thus it is against the constitutional provisions. Most of the developed democracies don't follow this system. So this is the criticism. You can remember it and quote it in your examination. Let's go down further. Due to this widespread criticism and due to the fact that the previous government since 1989 till 2014 they were only coalition governments, almost for 25 years coalition governments. 1981, 83 onwards, they were 89 onwards, they were continuously coalition governments for 25 years. But somehow in 2014 a majority government came into power and they brought in the 99th Amendment, and thus came the birth of National Judicial Appointment Commission, NJAC. What did the 99th Amendment do? It inserted Article 124A, 124B and 124C into the Constitution. The Collegium was dissolved and NJAC, National Judicial Appointments Commission, constituted. Hereafter, the judges of the Supreme Court and the High Court would be appointed as per the advice of the NJAC. That's what the 99th Amendment of the Constitution brought in. And what was the NJAC? We must understand its composition. The NJAC, or the National Judicial Appointments Commission, was a 6-member body. Obviously, the head was the CJI. There were 5 members. Who were these 5 members? 2 senior-most judges of the Supreme Court, 1 Law Minister of India, and 2 eminent members. Now, who were these 2 eminent members? These 2 eminent members were to be nominated by a 3-member body, and that 3-member body consisted of the Chief Justice of India, the Prime Minister of India, and the Leader of Opposition of India. In case any Leader of Opposition didn't exist, it was the leader of the largest party in opposition. And one of the eminent members must be either SC, ST, OBC, minority or woman. So this was the broad constitution of the NJAC. Further, the rule was that if 2 members were against recommending any name for appointment as Supreme Court judge, the name won't be forwarded. Thus, minimum 5 members were required to recommend any name. That 5 members of the NJAC should recommend any name for appointment as Supreme Court or High Court judge. The collegium was thus dissolved and powers came back to the President or the Executive. The NJAC's recommendations would be binding on the President, and this particular amendment was passed with a special majority and was agreed to by more than half the states of India. And such an important legislation was passed with the 99th Amendment. But it met with an unfortunate fate. What happened? In 2015, it was again challenged. The NJAC was challenged in the Honorable Supreme Court, and this is also known as the fourth judge's case. What happened? The NJAC was challenged in the court, saying that it impinges on the power of the judiciary. It curtails the power of the judiciary. This was also known as the Supreme Court Advocates on Record versus Union of India, again filed by the Supreme Court Advocates on Record. See, interestingly, the Supreme Court declared the 99th Amendment unconstitutional. What reasons it gave? Let's see. The reasons that the Honorable Supreme Court gave was that it interferes with the independence of the judiciary. The Honorable Court said the Constitution has taken pains to maintain independence of the judiciary. It is against the principle of separation of power, and thus it is against the basic structure of the Constitution, hence declared ultra vires. Further, it said that the so-called two eminent members, that is the law minister, the two eminent members and the law minister were not law qualified. We have taken years and years to study law to come to this state, and people, two eminent members and law minister, even if not law qualified, take a decision for appointing the Supreme Court judges and the High Court judges. Thus, the 99th Amendment was declared ultra vires against the Constitution and was removed. The Collegium came back. The Collegium, interestingly, came back. Article 217. We'll slightly digress and discuss Article 217. How are the High Court judges appointed? The Constitution says they will be appointed by the President only and not by Governor. Governor has got no role here. In appointment, yes. However, the President would consult CJI, the Governor of the state and Chief Justice of the State High Court. The President will appoint in consultation with these people, but the consultation is not binding. That's what the Constitution says. But since 1993, since the establishment of the Collegium, the appointments are being done by the Collegium. And here, in the appointment of the High Court judges, a very important point to note is that the Collegium is Chief Justice of India plus two senior most judges of the Supreme Court and not four. The present Collegium for other things is CJI plus four judges, but for appointment of the judges of High Court it is CJI plus two senior most judges. This point is to be remembered. Going down further, how does the transfer of the High Court judges take place? Article 222 talks about transfer of High Court judges. Important point to note is, it will be done by the Collegium only. But herein the Collegium, unlike appointment of judges, where it was, unlike appointment of High Court judges, where it was CJI plus two Supreme Court judges, here for transfer it requires CJI plus four senior most judges of the SC. That is the present Collegium as it exists in its present form. It will be done in consultation with the CJI of the concerned High Courts. Let's say a judge is to be transferred from Rajasthan High Court to Maharashtra High Court. The Chief Justice of Rajasthan High Court and Maharashtra High Court will also be consulted. So gentlemen, here we come to the end of this interesting discussion and we'll conclude. To conclude, we can say, given this conundrum, given this confusion, the appointment of High Court judges and the need for accountability and of higher court judges, that is Supreme Court and High Court, Need for accountability and transparency remains stuck between rock and hard place. But it's a situation which involves dilemma. What should be done? What should be done? The way forward is neither should the parliament be used to dismantle the Indian constitution brick by brick. The parliament shouldn't be dismantling the separation of powers at its whims and fancies. Nor is the bare principle of judges appointing judges correct. Nor is the present collegium system in its present form is absolutely correct. Both have its flaws. The answer lies in a more debated and thought through middle path with adequate transparency. A middle path after adequate public debate has to be brought in, and the tug of war should end in the interest of the nation. A better method, better method would lie somewhere in between the collegium system and the pure appointment by the sheer discretion of the executive. Hope I have been able to clarify the NJAC versus the collegium controversy. Thank you so much, and Jai Hind.